this expert witness made several findings, one of which is...
Is this expert witness the individual Haig?
Yes, sir. Yes.
I thought that he did not examine the car.
He did not examine the car, no, sir. He inspected the other evidence available to him.
Yeah.
And one of his complaints, one of the issues that is central to the issue in this case is the lack of the vehicle to examine reduces this investigator's certainty and, in some cases, ability to make conclusions about the relationships between the trajectories in bodies versus impacts and paths through the vehicle. However, some likelihoods can be evaluated. And then later on he states, unfortunately, none of the information available from the images from the scene or when the warrant was executed help to resolve a finite number of bullet passages through this region, referring to windows. Now, there's an issue here on multiple motions, whether 5 shots were fired or 6. There is going to be the issue of how these shots were fired and who may have fired them. So in the process of that, there's nothing more important than the vehicle itself that for some reason, and we still have yet to, throughout all of the discovery, have been able to identify why the car was returned and not preserved as the defendant's car is preserved. In fact, it's not even the defendant's car. The actual owner of the car wants it back and has been trying to get it back for the longest time, but the state is sticking to their position and, of course, doing the right thing as it relates to Mr. Hernandez's vehicle, but not to the actual vehicle of the victims, where, by their own experts' report, he's specifically saying, I need this car to be able to determine where the shots came from, what direction, and how many shots were fired. There were 3 of the 4 windows down in this car, which of course then brings into question the number of shots. Some information can be gathered by the trajectory from both the autopsy results and some of the tangible evidence that was photographed in the car. Proper inspection or proper analysis is hereby completely eliminated and unavailable unless someone somehow goes to the Republic of Georgia hoping that there's somebody driving around this car with bullet holes in it and that it hasn't been repaired and that the evidence is still preserved by some miraculous way, which is next to impossible.
All right. Supporting the motion, I have Mr. Leontier's affidavit, and then attached to that is the report of this individual, Michael Haig, H-A-A-G. Miss King is the last name. It's dated the end of November of 2015. I think that is the only forensic analysis report that was filed. But let me ask, with regard to the vehicle itself, are there other reports regarding the vehicle? Was there a crime scene services analysis of the vehicle?
There are crime scene reports that relate to photographs, the documentation of the evidence, but nothing as it relates to the analysis of the way.
Were there photographs of the vehicle taken?
That's another issue.
Or a videotape of the vehicle?
There's no videotape. Apparently the car was not even processed at the actual scene. It was taken to the forensic bay.
Yep.
And processed there. So we have issues on not only how it was processed, but where it was processed, and the fact that it was disposed of afterwards.
Yep.
And then the court was not, I guess they didn't acknowledge, we also have included in our motion a police report for when law enforcement recognized that they should not have gotten rid of the car and went looking for it and found it in the Republic of Georgia.
Okay.
So I think not only by the state's own expert, but also by the Commonwealth's directing of law enforcement to go and get the vehicle, clearly supports our position that this should never have been destroyed. And I guess that I don't have a problem saying it that way. This evidence should not have been destroyed. It should have been preserved. It wasn't preserved. And I think the defense deserves some type of remedy as it relates to this. That, of course, is entirely up to the court what it seems. But I believe there is exculpatory information, and I think if the court can follow my drift as to other motions that are before the court, as to the number of bullets that may have been fired, and how relevant it is to that evidence, we've got a problem, and a big one. We've got a problem as to, is the testimony that's going to be presented in this case before your court reliable evidence, evidence that could have been preserved and was not? I don't have specific evidence or can make the argument that this was intentionally done, because clearly, by the way the facts lay out, there's no rational reason why it would have been done. But I think gross negligence is something that the court can take into consideration when deciding a remedy for something of this magnitude. So I think the court has some significant analysis to do as to how we're going to be able to pull all of this off so that Mr. Hernandez's due process rights are not violated, in the sense that there's clearly things that are going to be alleged in this case for which, if we had that car, we would be able to know and would provide exculpatory information or information to the contrary. And I think how it relates to other pieces of evidence, the court needs to kind of keep that in the back of his mind.
Okay. The Commonwealth has this afternoon filed an opposition to the motion, and I haven't looked at it yet. It does seem to me that in considering whether or not there is a loss of evidence or a loss of exculpatory evidence, I have to weigh and determine what it is that is lost. That is, what cannot be otherwise established. That depends a little bit on what the police or officials did do when they had the car, what sort of examination took place, what sort of photographs took place, what was seen or potentially missed. And I think that I'd like to see that to the extent that's documented. So, Mr. Hagan, it would seem to me appropriate that I receive copies of any either crime scene reports, notes, or photographs, or other records showing what form and to what extent an inspection of the car was conducted.
Yes, Your Honor, we will provide that, and just in summary form for the court right now, I can tell you that that car was fully processed with the decedent still inside of it pursuant to a search warrant, that not only were extensive photographs taken of the entire car and its contents, but GSR swabs were taken of various portions of the car that were subsequently, that's a different car. The probes were placed into the bullet holes to show the trajectory of the bullet holes. Items of ballistic evidence were recovered from within, and anything of evidentiary value was in fact removed from that car prior to it being ultimately released. I just want to give the court one other point of relevant background and practicality to consider. Although Mr. Baez suggests that the release of this car was in some way negligent on the part of the police department, I can tell you that it is not the policy, protocol, or procedure of the Boston Police Department or state police to retain victim vehicles. Again, from a practical perspective, if the Boston Police Department retained every victim vehicle that involved a fatal shooting, there would be multiple lots within the city containing victim cars. They process the cars, they collect all relevant evidence, and they return them. If this argument were taken a step further, should the police prevent individuals who own homes or apartments, not allow them access back to the homes, and not allow them to repair the holes from bullets where other murders happen. So I think the point the Commonwealth...
Well, you do that all the time.
Right.
You freeze crime scenes all the time until you've done what you want to do.
Exactly.
And
once it's
the
fully
defense
processed-
is simply saying, well, we ought to have that same opportunity to do what we have to do.
One other point on that, though, Your Honor, and with all respect to the defense, all we know is that the car is in the Republic of Georgia. We do not know whether or not the car was ever repaired, whether or not the bullet holes were repaired.
Well, yes, but I take it they weren't repaired before the police released the car.
That is correct. And another important point that I believe is in the documentation before the court is Mr. Haig, in fact, purchased a headrest, the exact headrest of which is affixed to the BMW in question, and conducted experiments on the exact same headrest. The headrest is the only part of the car that had a through and through projectile relative to the trajectory analysis that Mr. Haig presented. So again, the Commonwealth will present the court with all of the reports and all of the photographs and all the evidence of the extensive processing that was done of the car to collect the evidence before it was released to its rightful owners.
Okay. All right, counsel, there are two new motions filed relating to plea agreements or sentencing agreements involving Mr. Bradley in Connecticut. Two motions are directed to Connecticut, and there's a third motion under Rule 14 directed to the Commonwealth as it relates to any plea or sentencing agreements or promises, rewards, or inducements relating to the Connecticut case. Mr. Hagan, as to the Rule 14 motion, it's an unnecessary motion in the sense that promises, rewards, or inducements must be disclosed without motion under Rule 14. But tell me, was there any involvement by the Commonwealth or its agents with regard to Mr. Bradley's case in Connecticut?
There was not, Your Honor. There was absolutely no promises, rewards, inducements, or other communications by the Commonwealth of Massachusetts or its agents relative to Mr. Bradley's pending case, or at least at the time pending case in Connecticut that was recently adjudicated. And in fact, we were advised of it being adjudicated by an attorney for Mr. Bradley. And again, I had confirmation from the prosecutor in Connecticut, who, by the way, is on our witness list as a potential witness to speak to this point. But she again confirmed for me that in no way did she consider Mr. Bradley's involvement in our case in her recommendation before the court relative to the plea in which Mr. Bradley pled guilty to.
All right, I'm going to order that you file a written response to the defendant's Rule 14 motion. Just memorializing what you've told me, there was no such promise, reward, or inducement, or I take it involvement by the Commonwealth with regard to the witness's Connecticut case.
We will do that, Your Honor. Just on a point I think raised in the defendant's motion that the court may have a question about, counsel has found in the transcript of Mr. Bradley's plea hearing a reference to the fact that I believe the judge imposed a condition of his ultimate parole or probation be that he abide by any subpoena process issued, presumably by Massachusetts courts. That, again, was done only to ensure that Mr. Bradley was, in fact, properly served and will appear as a witness in this case. It was not any promise, reward, or inducement, or a particular condition of his plea. And again, in fact, when the calls were made to the Commonwealth by the defense attorney for Mr. Bradley and then subsequent conversations with the state's attorney in Connecticut, they just wanted to make sure we knew that he was pleading guilty, his sentence could end at some point, and to make sure that he was served with out-of-state process to ensure his appearance in the Massachusetts court on this trial.
And is Mr. Bradley now serving a sentence somewhere?
Yes.
All right. With regard to the motion for production or to subpoena Connecticut authorities, Mr. Baez, do you want to be heard on that?
We'll be passing it to Mr. Lee.
Mr. Leontier?
Yeah, thank you, Ron. First of all, the characterization of the nature of how the matter here in Massachusetts related to Connecticut by my brother is not quite accurate. In fact, I received today, this morning before I left, and I made it known to Mr. Hagan, a copy of the plea agreement hearing. And the plea agreement reading, the assistant state attorney, Attorney Melchiori, stated to the court, this wasn't the court, this was the prosecutor, stating to the court, the state's recommendation had been 6 years to serve and 4 special parole. After discussion with the court, it's my understanding the court will impose 5 years to serve and 5 years special parole. Just for the court's information, he had already served 3 of those 5 years that he was getting sentenced to. The state would request that he pay restitution to the bar for any damages that he caused, and that if subpoenaed by the prosecutors in Massachusetts, that he appear in response to that subpoena. So that wasn't the court, that was the assistant state attorney. And when we get to the actual sentencing, it's very interesting because there's all these oblique references, like maybe it's a wink and a nod here, but we've got the court saying he's going to agree to the opposed upon sentence. And then he goes on to say, this is the court, it's been 3 years, but they're going to have to verify whatever it is. If you're subpoenaed, well, you have that obligation anyways. If you're subpoenaed, you're supposed to appear in court. So that is your obligation. But that is the only condition we have concerning what's happening. Good luck to you. The fact of the matter is, Judge, if we look at the case law with respect to inducements, it's irrelevant whether the Commonwealth was involved with respect to bias. There are numerous cases where the federal government has had people in custody and being charged where they have granted lenience without consultation with the states, and those agreements are admissible for the purposes of impeachment, just like any other matter for impeachment. If someone went to Mr. Bradley and offered Mr. Bradley a sum of money to testify against Mr. Hernandez, which isn't the case here, I'm not alleging that. I'm just using that as an example. That is an impeachable offense and an impeachable appropriate cross-examination.
I'm sorry, give that to me again?
I was using an example, maybe a little bad. I simply said, if someone offered something of value to Mr. Bradley to testify against Mr. Hernandez, that is right for cross-examination.
Of whom?
Bias.
Of whom?
Pardon?
Of Mr. Bradley.
Yes.
Someone offers him a bribe. He
motivation.
declines the bribe.
He accepts the bribe.
Oh, well, they kind of left that out.
Well,
He declines the bribe.
if he declines the bribe, then there's no bias. If he accepts the bribe, then there's bias.
Okay.
If he has any...
All right, now let's tie that into the Connecticut case.
Yes.
I take it the argument is that the Connecticut authorities, either on behalf of the Commonwealth or on their own, decide to grant an inducement that affects Mr. Bradley's testimony here.
Well, it doesn't even have to affect it, Your Honor. It has to, if it rises...
Yeah, in your example, Bradley accepted the bribe.
In that example, but to the extent that it is examinable for the purposes of bias.
To the extent it shows a bias.
Right.
I'm not quite sure how this would show a bias if it is nothing more than a court order as a condition of probation that comply with subpoenas if you're subpoenaed.
Well, Your Honor, first of all,
But let's not resolve it right now.
Okay.
It seems to me appropriate that Connecticut authorities be made aware of this and have an opportunity to be heard. And as well, the Commonwealth will have an opportunity to be heard. I think that notice has to be given, at least as to the motion for production of the Connecticut sentencing agreement or any cooperation agreement. We'll set that up for a Lampron hearing. In Commonwealth, I'm going to ask that you provide notice to the Connecticut State's Attorney or whoever the prosecuting authority was as to this motion and their right to be heard if they wish to be heard. As to the motion to subpoena Connecticut State's Attorney or those officials,
Can I speak to that?
yeah,
We're not looking for the state attorney, we're only looking for the assistant state attorney who handled this case and Mr. Bradley's lawyer. As you're aware, a favorable agreement does not have to be in writing. As a matter of fact, the court has said, to the extent that there's, well, we'll see what we can do for you later.
if there's an understanding, you're entitled to know about it and to present it if indeed
Right.
it
And we-
impacts the witness's testimony.
And we think that the conversations, which are not privileged, between Mr. Bradley's lawyer and the assistant state attorney to ferret out the question as to how this came about, how the discussion about Massachusetts came about, what consideration, if any, and what discussions there were, is fair game under the law for us to examine and to determine if, in fact, what transpired constitutes bias.
Okay. All right, let's first see what their response is to the motion for production. And then I'll consider the motion for subpoenas to those individuals. I have two motions before me for buccal swabs. One relating to Mr. Bradley, the other relating to Jaylene Diaz Ramos. With regard to those two motions, they would be appropriately subject to a Lampron hearing under Rule 17 with notice to Mr. Bradley and with notice to Ms. Diaz Ramos. If Mr. Bradley's in custody, likely he would not be able to respond for a hearing on that Lampron request. Jaylene Diaz Ramos, who is that?
She is an individual who the Commonwealth believes had possession of the firearm.
Is she the woman driving the car out on Route 91?
Yes, sir.
And are her whereabouts known by either side?
Yes, she is.
Mr. Hagan?
Yes.
Are you able to provide notice to her?
Yes.
Okay. Then let's set that up for a Lampron hearing at the next hearing that we will have in this case. In the Commonwealth to provide notice to Mr. Bradley and Ms. Diaz Ramos. Mr. Hagan, did Mr. Bradley have Massachusetts counsel at any time?
He did.
So is,
John Kiernan?
all right, is there someone you can communicate with regard to this issue?
Yes, Your Honor. I have communication with both his Connecticut attorney and his Massachusetts.
Okay, very good. All right, Mr. Bai, I'm sorry, are you addressing those motions, the DNA motions?
Yes, sir.
I'm not determining now whether or not you've made the necessary threshold showing because the motions were just filed, and I want to focus on what has been argued. It seems to me that the principal case that would apply in this motion is it In re Jansen petitioner? Are you familiar with that? I'll just give you the citation. It's 444 Mass 112. It's a 2005 Supreme Judicial Court decision on a defendant's request for a DNA sample or a buccal swab from a third party. And it seems that it's a different analysis. It's a due process analysis, different from the analysis the court would conduct if the Commonwealth were making this request, which would then implicate the Fourth Amendment or Article 14 and speak to those cases. Drahim and Koska, I think, was one case that we had in this session. So take a look at that. Let's give notice to these parties, and let's hear on the issue on the next scheduled hearing, which right now I'm hoping to hold on, if we can do it on February 1. All right, the one other motion that is before me is a motion to exclude improper argument. As a general proposition, I will exclude improper arguments by either side, but as to this particular motion, we can take that up at the next hearing. There's no need to discuss that today. And I think those are the substantive motions that are before me today. I do want to discuss some procedural and logistic issues relating to how this case will proceed. What I'd like to do is take perhaps a 5-minute recess, and then we'll take up those issues. All right?
All right, please.